discovery request. We've issued initial disclosures that were due by the defendants back in July. We've also issued interrogatories and requests for production, which those were due back in October. And me and a couple of other attorneys in my office had tried to get in touch with Mr. Valdez. I'm actually surprised that he's here today. I was expecting him to not show up because we just haven't received any responses, any communication. I know another attorney in my office has left a voicemail or left a message with his secretary to follow up on these matters. We just haven't received any responses to either the disclosures, the interrogatories, or the request for production. So we're asking the court to order the defendant in this matter to respond to all three of those. And now that the time has passed, the responses are without objections.
Okay, response?
Your Honor, very briefly, I'm not sure when counsel says that I was unavailable or whatever it may be. What I can tell you, Judge, is this is an interesting case. It's an employment dispute. The plaintiff used to work for my client, the defendant. Unfortunately, Judge, the plaintiff has already passed away. And interestingly enough, prior to Ms. Dixon being retained or taking over the file, Mr. Lee asked me, and we communicated and cooperated very well together. Mr. Lee took a deposition of his own client to preserve evidence, which was a little bit unusual, but I didn't dispute it. I didn't file a motion to quash. We attended the deposition. At the time, full disclosure, Your Honor, I was a little bit, suspicious that maybe Ms. Case was not being forthcoming with her health, but unfortunately, Your Honor, between the time that we took the deposition to preserve evidence and the time that they served me with discovery, Ms. Case passed away. Since then, they did serve discovery requests. And I will be fully candid with the court. If you take a look at your docket, Judge, and I looked at it very briefly to familiarize myself with where we were, they filed a second or a first amended complaint. And I can look, and I can even share my screen, Judge, if it's necessary. But the original plaintiff was Victoria Kleiss. As far as I can tell, the plaintiffs never filed a suggestion of death or anything of that nature. They just filed an amended petition where it now is Jessica Gonzalez as the administrator of and on behalf of Victoria Case deceased. Now, Judge, I have no reason to suspect or believe that Ms. Case is not deceased, but procedurally things should have been done differently. That said, I can represent to the court that I did receive discovery requests, and I can also represent to the court that I did not respond to them, nor did I pose objections. Whether or not I was contacted by opposing counsel, once again, and I think Ms. Dixon will probably confirm that if I recall correctly, Judge, and it's tapped in my memory because I'm on a 3-day work week now under Corona, which is yesterday, today, and tomorrow. I don't dispute that they have communicated with me, but they've gone through a series of lawyers on this case and also a deceased client. At this point, I don't have a problem, Your Honor, responding to their discovery requests. What I would request is that, Your Honor, there is good cause. We all know the rules under, whether or not you've waived objections, but I do have good cause to say, well, wait a minute, guys, hold on. What's going on here? First of all, there was 3 other lawyers maybe, I don't remember. And then there's apparently a deceased plaintiff. And there's now an amended petition with Jessica Gonzalez as the administrator of. I have no idea, Your Honor, who Jessica Gonzalez is. I don't know if she's an heir. I don't know if she's an administrator in the sense that it was probated. What I would respectfully request that this court does is give me 30 days to respond to their requests without having waived any objections. And I can tell you, Your Honor, I think I've been practicing in your court long enough to know you don't like bogus objections. I suspect that if there's 20 requests for production, I may respond with objections to 2 or 3, which are the main objections, whether it's proprietary or confidential, because these are employment records, or whether it's privileged. I would respectfully request, Judge, you go ahead and grant their motion to compel. Give me 30 days to respond, but preserve my objections based in light on all of these crazy things that are going on, Judge. Not only do we have the COVID, we've got a plaintiff who passed away, no suggestion of death filed, and then an amended petition purporting to have an administrator that nobody really knows whether or not she is or isn't an administrator, if there's been a probate or not. So with all due respect, Judge, I have failed to respond to those requests. I could have probably just blanketed said, I'm not answering anything to anybody unless the old Abbott and Costello skit. I need to know who's on first. So with all due respect, Judge, they are correct in the sense that I've not responded to discovery, but there's a reason for that. And I would say with good cause, Judge, go ahead and order that I respond, but preserve my objections and give me 30 days.
Ms. Dixon?
This is the first that I'm hearing that he had issues with any procedural things that had done. Miss Case did pass away. The administrator of her estate was substituted as the plaintiff because Miss Case is no longer living. But anytime that we had contacted Mr. Valdez regarding these issues, we got radio silence. And we did, there was another associate who was on this case prior to me taking over. She contacted him on December 11th, left a message on January 14th. And then I also emailed him on April 7th before filing this motion, and I never got a response. I also filed the motion, and I was expecting maybe that would get Mr. Valdez to reach out to me so we wouldn't have to have this hearing and we could work these issues out. But I got nothing. Not until today is the first time that I've spoken to Mr. Valdez since we've had these issues. So I'm asking the court that these have been outstanding for many months, an additional 30 days. I would like to, I'm asking for 10 days from this time the court has signed the order, because he's had plenty of time to get these responses together. Whether the plaintiff is Miss Case or whether it's her estate, it has no bearing on the documents and information that the defendant has. So we would ask this court to order them to respond without objections, because although I hear what he's saying, we didn't know of any of these procedural issues, and we could have worked these out months ago if that was truly a problem. So we would ask that the responses be without objections.
Brief reply, Your Honor, to the extent necessary. I can confirm that Ms. Dixon did send me an email. I received it, Your Honor, and with full candor, I did not respond. I was scrambling, like I said. In fact, you can ask Judge McFarland. I had 3 hearings set back to back, which were all like unilaterally rescheduled. So I'm scrambling. I can confirm Ms. Dixon's representation. I received an email from her. I did not respond. My apologies for that. As far as the law is concerned, Judge, here's one thing that I think is very important. When she says she doesn't know, I'm sorry, when counsel says they don't know about the procedural issues, my concern, Your Honor, is, wait a minute, we've got a deceased. There are ways that you are supposed to do this when a plaintiff passes away. As far as I can tell, Judge, I don't know who has standing to be able to do this. I'm not the person that's supposed to say, I mean, maybe I could have filed a motion for summary judgment for lack of standing, but unless they've probated it and they have a family court judge that says, Ms. Gonzalez is the true, whether she's an heir or an administrator, I'm caught between a rock and a hard place, Your Honor. And I think perhaps your court may be in a position that if we do certain things and we don't know whether or not the plaintiff has standing, it would be all for naught. So when counsel says they're unaware of procedural issues, these are the plaintiff's procedural issues, not the defendant's. I just need to know the old Abbott and Costello, who's on first.
All right, so this is what we're going to do. I understand, Mr. Valdez, a bit of a confusion here, but you should have responded, obviously. So we're going to give you 21 days to respond to discovery. I'm going to kind of take you on your word a little bit, and so I'm going to allow you to have one objection to one of the requests for productions and one objection to one of the requests, one of the interrogatories. All the rest of the objections are waived. And Ms. Dixon, you are going to need to, file a suggestion of death, look at doing a writ of seri facias, and make sure that you get these procedural issues taken care of, because he's right that if you haven't filed either of those, then you haven't done this correctly, and you need to look into that.
Okay.
Your Honor, if I may, just to make sure I understand your ruling, all but to the extent that there is a request for production and interrogatories, I can choose which, so for example, if there's 25 interrogatories, I get one objection. Pick one, Mr. Valdez, and you're lucky you get that. And
Yeah.
if there's request for production, I get one objection for however many requests for production that is.
You can object to one of the requests for production and one of the interrogatories. I'm not saying you can just make one objection. You could make 50 objections to each of those, but it's just to one each. And really, if I was following the rules, I probably should make you waive all your objections, but I'm trying to kind of be fair here. So I want to give you a chance if there's something really problematic in there to make an objection. If Ms. Dixon, if you're planning on mandamusing me on that, hopefully you won't, then I may have to reconsider that order. But just in fairness, because there is a little bit of confusion here and it's the COVID crisis, I want to give Mr. Valdez at least some chance to try to do objections. So you can object to up to one of the requests for production, up to one of the interrogatories, as many times you want. Ms. Dixon, you'll need to prepare an order for me that kind of confirms that. And it'll be 21 days from today that these will be due.
Okay. Do I need to email that or file it?
You'll need to do both. You'll need to file it, then email it to Rhonda.
Okay.
Judge, real quickly, I'm not sure how the process is working in your court. When Ms. Dixon both e-files and emails it to your coordinators, how soon will the other parties receive a conformed copy to the extent you signed it today? If you signed it today, do you have any idea when we'll get it?
You know what? We don't mail it to you. You know that none of the clerks are not mailing these things out, so you'd have to look it up. It's actually going a little bit quicker because we're now able to. What I'm doing right now, I'm working remotely, so I will scan it in. I'll get the order. I'll sign it, interline it if I need to. I'll scan it here at my house and then email it directly to my clerk. And I think she's filing it almost immediately. And so from that sense, it may be even quicker, but it's going to depend on when Ms. Dixon gets me an order. And so it's fairly quick, but you'll, Ms. Dixon, send a copy of the order over to Mr. Valdez, give him, 3 or 4 hours to take a look at it. And then if he doesn't respond, then you can, 3 or 4 hours during the workday. Don't email them at midnight and then send it to me at 4 in the morning. But 3 or 4 work hours, give them some time to look at it. But I understand you want to get it to me as quickly as you can. You guys have any other questions?
I don't think so.
Judge, I wish I could have you on the line to quiz you on how this COVID and other policies and procedures, but for purposes of this hearing, Your Honor, I think you've made it clear what your ruling is and what the lawyers have to do, Judge.
And I would take a look at that if you want to go to my YouTube page. Take a look at the, take a look at what that interview. I think it does a pretty good job of talking about the emergency order. And I will tell you this: we're handling hearings just like we did before, with the exception they're remote. We're handling temporary injunctions. We're doing non-jury trials. The only thing that we're not doing is jury trials. So everything we used to do, we're doing now just remotely, except for jury trials. And we've already kind of tried one non-jury case. We have a bunch of non-juries set next week, and we'll see how many of those actually go. But, I'm trying to keep just as busy as I possibly can.
And those will be live on YouTube. So if you've got
they'll be live on YouTube, so you can watch it or go back and watch it later. Get your popcorn out and have a great time. So some of the hearings are pretty interesting. So, but I have my next folks kind of showing up for my next hearing. So it's great to see you guys. And I'm going to go ahead and turn off the YouTube. I should have done that already, but